Welcome to Planning for Protection.
Welcome back to Planning for Protection with attorney Jeff Ryder. Jeff is an elder law and estate planning attorney serving families across Carroll County and the surrounding Indiana communities. I'm Evan Mack, and today we're talking about powers of attorney. Jeff will explain what they do, why they matter, and how they protect families long before a crisis arrives. Jeff, welcome back, sir.
Well, thank you, Evan. It's good to be back. Merry Christmas to you.
Merry Christmas to you as well. Jeff, when families meet with you for the first time, what kinds of situations usually make them realize they might need that power of attorney in place?
Well, ideally, they've been thinking about it for a while, and they realize, we're in our 40s or 50s, and life is unsure. None of us know what tomorrow holds. And so we can do our best to be prepared for that or not. So hopefully people are thinking about that. But what sometimes triggers it is, mom had a fall or a stroke or an event, and we suddenly realize we need to be able to do stuff for her. And so that those crisis events trigger them, but ideally you're thinking about it long before the need ever arises.
Absolutely. Indiana recognizes different types of powers of attorney. What's the basic difference between a financial POA and a healthcare POA, and why does someone typically need both?
In the old days, we used to do a combination of a financial and a medical power of attorney. But, and I don't know, maybe 3 or 4 years ago, Indiana, maybe longer now, time flies, Indiana changed their laws regarding medical POAs, and it's not even possible to do a medical power of attorney now. The Indiana wants those to be placed into a health care representative designation. And that's where you essentially do the same thing you did in the medical power of attorney. You name a person or persons, oftentimes your spouse, maybe some of your trusted children, maybe all of your children, to be healthcare representative designees for you to be able to talk to the hospital, the doctor, and not only get information, but also make decisions on your behalf if you're not able to. And so if there's, at a life-threatening situation and the decision to pull the plug or not to pull the plug needs to be made, if you're not able to communicate, who's going to do that? And so that's why having a healthcare representative designation is important. The corollary of that, of course, is a financial power of attorney. And Indiana has a pretty expansive list of powers that you can delegate to someone who's acting as your financial power of attorney. And that can include things like real estate. You need to sell your real estate, lease your real estate, put a mortgage on your real estate. That you can delegate all that power. Same thing with personal property, such as vehicles or tractors or anything that is of personal property nature. And there's banking transactions. That's a huge area. You can put somebody to be able to write checks on your behalf, to pay bills, to transfer funds to cover your, whatever your obligations are. And another one is trust powers. You can give somebody power to act as a trustee on your behalf, to be able to do, to create a trust. If you need to create a trust, it would be beneficial. And there's so many powers. And some of the newer powers are digital powers over digital assets. And I had one of my first estates recently where they had a digital currency. I forget the exact name of it. Maybe it was Bitcoin. It doesn't seem like it was Bitcoin though. One of them. And and thank goodness they knew the key to get into the account, because that can be a real significant issue. I've had other clients who they thought they had digital currency, but they had no way to get into the account to access it after their loved one died. So it can be a very dangerous situation if you don't have those information recorded in a place that can be accessed if you become either dead or unable to access them yourself. So the power of attorney can provide a lot of very beneficial benefits to be able to handle any kind of situation that might arise. And what that does, it helps avoid the need to establish a guardianship. Because if you don't have a power of attorney and as a situation arises, your family may have to go to the court to say, our loved one is unable to manage their affairs right now. We want to become guardian of their person and estate, person and or estate. And the court, has a hearing, there's a determination made, there's evidence presented, and that takes time and that costs money. And so if you don't need to do all that by having a power of attorney, you just save yourself some time and trouble to not have to have a guardianship established.
Wow. So many people assume a spouse or adult child can automatically step in if something happens. What problems can arise when a POA isn't already signed, Jeff?
That here's my understanding, and I may be not totally correct on this, but I think if it's a life or death situation and you're the spouse and there's nobody else to say something, they will at least listen to your thoughts about it. But the far better option is to designate people that you trust and and are willing to let them make that decision. Because if you don't, the doctors are really in a situation they don't know who's entitled to speak for this person, and how do we know they are? And that's where the healthcare representative designation comes into play. It makes it clear who's in charge and who's has the ability to make those decisions that are needed.
So, Jeff, capacity is something families often worry about. What should people know about when a POA must be signed, and what happens if someone waits too long to sign it?
Well, if they don't have capacity, then the guardianship issue becomes very apparent, because somebody's got to do it, and sometimes they got to do it pretty quickly, and so you've got to rush to court and get that guardianship established and try to. Usually, that's an emergency guardianship, and then the court will set a hearing on it for a final guardianship. So you can avoid all that by having a valid power of attorney done while you still have capacity and are competent to do so.
Mm. So a lot of POAs are downloaded online or pulled from old paperwork. What issue do you see when forms aren't tailored to Indiana law or aren't updated as people's lives changes?
Yeah. So one of the big issues is the ability to make gifts. And so Indiana says if the attorney, in fact, the person who's appointed as power of attorney, is making gifts, he can do that to the family in an unlimited amount of money. But if he's making a gift to him or herself, he's limited to the so-called annual exclusion amount for federal gift tax purposes, which is currently $19,000 per calendar year per person, per donee. And so if you are the power of attorney, you could give, 100,000 to each of your siblings, but you'd only be able to give $19,000 to yourself. And so we very routinely override that statutory limit in Indiana by saying if the power of attorney is acting in good faith and they're being fair to the family and they're following the estate plan of their parent, they can treat themselves the same as they would treat a sibling and make gifts that exceed the annual exclusion amount. So we can override that limit. And it's important to do so, especially in a Medicaid planning situation, because, sometimes you are making gifts more than $19,000 in one calendar year. So that's a key thing. There's many other things that that generally speaking, I feel like creating a power of attorney is not that expensive of a thing to do. And it's well worth it, I think, to meet with somebody to make sure you understand what you're doing and doing all of the parts of it that would make most sense for you and for your family. I think everyone should avoid trying to download them and do them, doing by themselves, so to speak. They should get guidance and let an attorney help draft that, and it would be far better outcome.
So Jeff, can you share a story, maybe, or an example, where you having the right POA in place made difficult decision much easier on the family?
Oh, there's a million of those stories. I mean, I see it every day, literally, where kids are coming in and saying, I've got to get the bills paid. Is there a power of attorney? Or usually they know there is a power of attorney. They already have a copy of it. But occasionally they're like, did mom or dad have a power of attorney? And who is it? And we can say, yes. You know, he- uh, the, you are, or your sister or brother is the power of attorney. And you would, also, of course, in the healthcare situation all the time, and especially in an end of life situation, or what could be an end of life situation, having a designee in place is key to be able to get those decisions made in a quick and a timely and appropriate manner. So every day I see those examples.
Mm. So, Jeff, real estate often comes up in your planning work. How does a properly drafted POA help with property transfers, refinancing or protecting the home if someone needs long-term care?
Well, exactly. If you don't have a person in place, to act as power of attorney, then that falls back into the guardianship territory. And having that power of attorney, it makes all the difference. Oftentimes, if you are headed to a nursing home, you are not, maybe you're not very mobile, maybe you're not totally with it, and so there's all kinds of mitigating factors that would make it very difficult for you to participate in and do the planning. And that's where a power of attorney comes into play to be able to make those calls, make those decisions, and do the things that are needed. And it becomes a very urgent thing sometimes, because when families start writing $10,000 or $12,000 checks every month, it gets their attention, and they're usually like, we got to do something about this. And so the first moment of the first day of each month is a new window. And so we're always planning to achieve eligibility as of the first moment of the first day of a particular month. And so it's a lot like a football game. We're trying to score a touchdown and get across the goal line by that first moment of the first day of the month that we're shooting for eligibility for. And so we do everything possible to make that happen and get people eligible as quickly as possible so that they can, not see all of their life savings dissipated in a very rapid manner at the nursing home.
Absolutely. Some families are surprised that, banks, hospitals, or other institutions may have their own requirements. What should people check to make sure their POA will actually be, accepted when they need it?
Well, very good question, Evan. And that is a very common situation. So, what people need to do is, as soon as they start thinking about eligibility, they need to send a copy of their power of attorney to the institution that their parent has their assets with, the insurance company, the bank, the pension company, all those things. And each of those entities will often take up to, at least 3 or 4 days, up to maybe 2 weeks to review them and make sure that they fit, what their criteria are. And of course, the ones we draft are always fine, because we draft them that way. But they've still got to go through the process of get that recognized at the company to be able to take action and do the things that need to be done.
Mm. So, Jeff, for someone who has a will or trust but no POA, what's the most important reason to add these documents to their planning now instead of waiting?
Well, I think all those documents you mentioned can be very important. A will, a trust, or a power of attorney. They all have their uses, and if you don't have them, it can be a very unsettling journey for people to have to undertake when they don't have those things to guide them. If you don't have a will, Indiana has made a will for you, and that's the intestacy statute. And that is the list of rules that govern what happens when a person dies without a will. And sometimes, well, often really, that intestacy statute does not match what we imagine the person really would have wanted had they taken the time to do it. And so it's a very important thing to avoid intestacy, and that can be done either with a will and or a trust. And ideally, if you have a trust, you also have a will to pour over anything that isn't in your trust at the time of your death into the trust. And then your executor or trustee can administer one pot as opposed to trying to administer two pots. And so it's important to have all of those things.
Amazing. Jeff, appreciate your time.
Evan, thank you very much. I appreciate the time to be with you.
Awesome. That's it for today's episode of Planning for Protection. If you'd like to learn more about attorney Jeff Ryder and his work at Jeffrey C. Ryder Attorney at Law, LLC, visit jryderlaw.com. Thank you so much for listening. Remember to like, subscribe to the show, and share this episode with someone who might need it as well. Thank you so much, and we'll see you next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.